Senator Mary Torres, Senator Tony Abbott, Senator Underwood, Vice Speaker Cruz, Senator Frank Blas Uggan Jr., okay, I'm going to need 2 more so we can have a quorum and we can proceed. The Legislature in Guam is called to order. I would like to ask Senator Underwood if you can lead us in prayer.
If we could please bow our heads. In the name of the Father, the Son, and the Holy Spirit. Lord, we come before you this morning humbled, Lord, by the blessings that you continue to pour upon our island. And we come to you again, Lord, humbly asking you to, first of all, forgive us for falling short of your glory and your expectations. But we also come to you, Lord, grateful that you are a forgiving God, that you continue to pour upon us and our loved ones and our island your unconditional love. And so this morning, we, as your senators here in the island of Guam, come to you, Lord, to ask you once again to please pour down your Spirit upon us. Please give us your wisdom, your knowledge, your understanding, and most of all, Lord, your peace, that as we make decisions during this session, we would be guided by your will. Help us to work together, Lord, on behalf of your people. Help us, Lord, to set that example that you want us to set, just as Jesus has set for us when he walked the streets, when he walked the marketplace. And so with this, Lord, we again come to you to ask you to please heal our land. Heal our land. And with this, Lord, we thank you again for your blessings. And we ask all these in the name of the Father, the Son, and the Holy Spirit.
Thank you, Senator. Senator Uggan, can you lead us in the recitation of the Inifresi?
Inifresi. Gini mastakulu, gihina soku, imastakulum, di corazonu, dan imastigu, dan inasinahu, hu ofresin maisazu, para bayu protehi, dan hu defendi, ihinengi, ikutura, ilinguahi, iaili, ihanu, dan itanu samoro. Ni resaku, diretsu, gininatsu ustata, esti hu afirma gihilo i Biblia, dan ibanderahu, ibanderan guaha.
And if Senator Munir Barnes, you can lead us in the singing of the Guam hymn, and Senator Tony Abbott in the singing of the national anthem. Thank you, Senators. Can the clerk please take roll call?
Senator Tom Abbott. Senator Tony Abbott.
Good morning, President.
Senator Uggan. Senator Blas. Vice Speaker Cruz. Senator Espaldon. Senator McCready. Senator Morrison. Senator Munoz Barnes. Senator Respicio. Senator Rodriguez. Senator Nicholas. Senator Torres. Senator Underwood. Speaker Wampat.
Kaya.
Madam Speaker, there is a quorum.
Thank you very much. Senator Respicio, you recognize and some motions.
Thank you, Madam Speaker. Good morning. I move that those senators not yet present for session be excused.
The motion without any objection, so ordered.
And I move that we approve the legislative journals dated April 27 through May 1st, 2015, as well as May 14, 2015, subject to
Hearing
corrections.
no objection, so ordered.
Madam Speaker, there are communications and petitions that I move that they be pen a day session journal.
No objection, so ordered.
And of equal interest, as you had brought up in the Committee on Rules, there is a communication from the Federated States of Micronesia Congress, and at this time, I would like us to recognize Senator Nicholas to read a resolution that was presented to you by the Speaker of the FSM Congress, and to have this resolution not only read into the public record, but also so that people of Guam can also have the availability for the people of Guam to recognize their appreciation.
Senator Nicholas.
Thank you, Madam Speaker. Madam Speaker, not too long ago, the people of the Federated States of Micronesia were affected by Typhoon Maysak, and our people rallied to provide them with some support. We now have before us a resolution that was adopted by the FSM Congress expressing their gratitude to the people of Guam, and I'd like the opportunity to please read this into the record.
Please proceed.
Also, Madam Speaker, I would like for the opportunity for my colleague, Senator Frank Blas, to also join me in reading this into the record, specifically the be it resolved clauses at the end of the resolution. The resolution reads, 19th Congress of the Federated States of Micronesia, first regular session, May 11th to the 30th, 2015, resolution number 19-02. A resolution expressing the sincere gratitude and appreciation to the government and people of Guam for their supplies, financial support, and hard work in relief efforts to assist the people of the Federated States of Micronesia in recovering from Typhoon Maysak. Whereas the government and the people of Guam have provided supplies and financial assistance and donated items to the Federated States of Micronesia to assist in the relief efforts in the wake of Typhoon Maysak. The government of Guam, its separate departments, students, churches, and charity organizations collected donations and funding for our victims of Typhoon Maysak, and our states of Yap and Chuk benefited from the generous donations and assistance from the government and the people of Guam. The government and people of Guam have contributed enormously to the relief efforts of the victims of Typhoon Maysak in the Federated States of Micronesia. And whereas the 19th Congress of the Federated States of Micronesia recognizes the extent to which the nation has benefited from the supplies, financial support, and hard work of the government and the people of Guam.
Senator Abbott.
Thank you, Madam Speaker. Be it resolved by the 19th Congress of the Federated States of Micronesia, first regular session 2015, that the Congress hereby expresses its sincere gratitude and appreciation to the government of Guam, to the government and people of Guam for their supplies, financial support, and hard work in relief efforts to assist the people of the Federated States of Micronesia in recovering from Typhoon Maysak. And be it further resolved that certified copies of this resolution be transmitted to the President of the Federated States of Micronesia, Governor of Guam, Speaker of Guam Legislature, and the Secretary of the Department of Foreign Affairs. adopted May 15, 2015, Wesley W. Semina, Speaker, FSM Congress.
Thank you very much, Senators, and for the listening audience. This is a resolution from the Congress of the Federated States of Micronesia extending their appreciation for all of the efforts from the people of Guam and the government of Guam in providing financial support, supplies, and other materials. Thank you, Senators. Senator Respicio.
Thank you, Madam Speaker, and thank you, colleagues. Madam Speaker, there are messages from Imagala and Gohan, and I move that these messages be penned in today's session journal.
Hearing no objection, so ordered.
As well as reports of standing committees, I also move they be penned in today's session journal.
Hearing no objection, so ordered.
There are no reports of select committees, but on item 12, under one motion, I move that bill numbers 86-33LS through bill number 93-33LS, bill numbers 94-33 COR to bill number 102-33 COR, resolution number 75-33LS through resolution numbers 93-33LS, resolution numbers 94-33 COR to resolution number 106-33 COR, resolution number 107-33LS, resolution numbers 108-33 COR through resolution number 111-33 COR, certificate numbers 23-33 LS to certificate number 26-33 LS, as well as certificate numbers 27-33 COR to certificate number 42-33 COR, all be given its first reading.
Hearing no objection, so ordered. Senator, on motions?
Thank you. I move that any resolution or certificate of congratulatory or condolence in nature that's introduced for the duration of this session, that they be adopted, and that the sponsors work with the clerk and the legal counsel in the preparation of these documents, as well as having all senators co-sponsors.
Hearing no objection, so ordered.
There's another motion that there was a committee report on the appointment of Shelley Calvo. Senator Barnes, do you have that? Yeah, I know, but yeah, so there, so I moved that on the appointment of Michelle Calvo to the Guam Visitors Bureau Board of Directors, I moved that that be placed in the voting file. It should have been done in rules, but somehow it didn't, it wasn't moved.
Hearing no objection, so ordered.
And under legislative concurrence, from the Committee on Health, Economic Development, Homeland Security, Senior Citizens, on Senator Rodriguez's report of the nomination of William Castro to serve as Director of Bureau of Statistics and Plans with the committee's recommendation to pass, I move that be placed in the voting file.
No objection, so ordered.
Also from Senator Rodriguez's committee on the nomination of Dr. Ryan Claros to serve as a physical therapist representative on the Guam Board of Allied Health Examiners with his committee's recommendation to pass, I move that be placed in the voting file.
Objection, so ordered.
And finally from, two more, and from Senator Underwood's Committee on Early Learning, Juvenile Justice, Public Education, and First Generation Initiatives, on her committee's report on the nomination of Dr. Lisa Cooper-Nurse to serve as School Principal Administrator Member of the Guam Commission for Educator Certification, with Senator Underwood's committee's recommendation to confirm, I move that be placed in the voting file.
Hearing no objection, so ordered.
Then the item that we just placed regarding Michelle Calvo to serve on the Guam Visitors Bureau Board of Directors, I move that that be placed in the voting file with the recommendation to confirm.
Hearing no objection, so ordered. Senator.
Madam
Respicio.
Speaker, I'm told that there's another nomination for the Guam, two more nominations for the Guam Preservation Trust that committee reports have also been filed. Can I just ask for a brief recess?
Okay, we're going to take a brief recess. Second session, Senator Respicio.
Thank you, Madam
recognized.
Speaker. Madam Speaker, since we passed motions, I have to make a notwithstanding motion that we place the appointment of Cecilia E. Kraft to serve as member of the Guam Historic Preservation Review Board for the archaeologist, the alternate position, and the committee report was filed on May 22nd, 2015. So I move that this be placed in the legislative concurrence file.
Hearing objections, so ordered.
Thank you. And now that we're back in the legislative concurrence file, I move to place that nomination into the voting file.
No objections, so ordered.
Okay, I have no further motions at this time, Madam Speaker.
Thank you very much, Senator. Resolution number 83-33 LS. Senator Abbott, you're recognized.
Thank you, Madam Speaker. I move that resolution number 83-33 be moved to the third reading file. I'd like to discuss it.
You may proceed, Senator.
Thank you, Madam Speaker. You know, just yesterday we observed Memorial Day, and it was really a real beautiful ceremony down at the Veterans Cemetery down at PT. And then after that ceremony, there were other similar ceremonies that was held, one in Maritzo and one in Umatec, for those respective villages to really recognize and honor the sons of the village who had made the ultimate sacrifice. So it's really appropriate that we take up resolution number 83-33 and the companion document that goes with it, which is bill number 92-33. But very simply, what resolution 83-33 does is it is asking our delegate in Congress, Madeline Bordallo, to introduce legislation asking the federal government to transfer over property that is being held by the federal government and it's adjacent to the Veterans Cemetery, so that as the cemetery space gets used up, then we would have this little bit of space that would be available for future expansion. And so for that purpose, then we are asking the delegate to introduce legislation that would allow for this transfer. What we certainly want to avoid is that when the capacity at the Veterans Cemetery in PT gets all used up, that then we have to open up a second Veterans Cemetery and have to operate a different location. And as much as possible, I think we should lean forward and anticipate that capacity is finite down there, and whatever adjacent property is available, that we should try and annex that for the veterans, for the expansion of the Veterans Cemetery. And so if you take a look, there is an attached map. And if you just pretty much the way it's oriented as it's attached to your map, we're really talking about, there's this, if you take a look at the top of the map, just below all that legend and all that stuff, there's these three pieces of property, and it's very hard to read the letters there, but if you take a look, bounded on the west side is Marine Corps Drive, and then bounded on the north side is Spruance Drive. That's the road that goes up to Nimitz Hill. And so the three properties that we're looking at there, or at least the property in question, so the property on the upper left corner of that map, upper leftmost corner, just south of Spruance Drive, is that's the Veterans Cemetery there, and adjacent to it to the east is the property in question that is in the hands of the federal government and that we're asking to be transferred to Gov Guam. Now, not all of that land is going to be really developable for the cemetery, and so whatever is not available really would then be utilized jointly with the Department of Agriculture, which currently operates the Mosso Reservoir Conservation Area just to the east of that. And so that's what resolution number 83-33 does. And it is, I'll just read the title, it's to request the U.S. government to transfer Lot Apra Harbor Reservation B7 to the government of Guam to be reserved in perpetuity for the future expansion of the Guam U.S. Veterans Memorial Cemetery and the Mosso Reservoir Conservation Area. The Mosso Reservoir Conservation Area is put in there because to the south of that tract of land is really wetland and probably would not be suitable for cemetery operations. And so what cannot be used for cemetery operations will then be utilized as part of that conservation area. So I ask my colleagues to favorably consider this resolution, and so that we can send it to our Congresswoman in Washington, D.C. to introduce legislation to get that property back. Thank you.
You're welcome, Senator. On the motion? There being none, so on the motion then to send Resolution 83-33, the third reading file. No objections, so ordered. Bill number 92-33 LS, Senator Abbott. You're
Thank you,
recognized.
Madam Speaker. And my colleagues, if you've that last map that I was referring to, if you just keep that open so that we can make reference to it. But what Bill 92 does is it deals with the Veterans Cemetery itself, and it seeks to rectify a boundary issue. Oh, I'm sorry.
Yes,
I move
thank
that
you.
Bill 92-33 be moved to the third reading file, and I would like to discuss it.
You may proceed, Senator.
Thank you, Madam Speaker. Now, Bill 92-33 is really simply what it does is it seeks to rectify a boundary issue on the northeast corner of the cemetery. So what happens then is that because of an oversight in the past, there's about 25 graves that were placed outside of the Veterans Cemetery boundary. And so what Bill 92 does is it really seeks to adjust then the boundary of the Veterans Cemetery so that those 25 graves will fall within the boundary of the Veterans Cemetery. Now, in doing this, we're really talking about a small sliver of property that's involved here. But according to the Department of Land Management and their professional land surveyor, we can't just go in there and make an adjustment to that small sliver of property. They really need to go in there and basically survey the two adjacent properties, which is the Veterans Cemetery and the property to the east of it, which is the Mosso Reservoir. And so they have to go in there, survey those two properties, combine it, and then sever it, and then come up with a new map. It seems very involved, but I'm not going to question, I'm not a surveyor, and I'm not going to question the professional territorial land surveyor as to why we need to go through all that just to make what seems to be, in our layman's mind, a real simple adjustment. But now, during the testimony, the director of the Department of Land Management indicated that this is really a workload that they would ask that it be outsourced. And so they are asking that we appropriate the sum of $30,000 to be able to outsource it or to purchase additional equipment to be able to complete this task. Now the question then is, so where are we going to get the $30,000? And in the bill, I propose on page 3 that the sum of $30,000 be appropriated from any excess revenue collections and deposits into the Land Survey Revolving Fund, or from the 2016 projected collections and deposits into the Land Survey Revolving Fund for the purpose of contracting professional surveying services or procuring needed survey equipment to accomplish the provisions and intent of this act. So, Madam Speaker, I ask that my colleagues favorably consider passage of this bill so that we can rectify this error in the boundaries and make sure that the 25 graves that are currently outside of the boundary are then placed within the boundary of the Veteran Cemetery through the adjustment of a boundary that can only be done through surveying. Thank you.
You're welcome, Senator. On the motion, I have the Vice Speaker.
Thank you very much, Madam Speaker. Madam Speaker, I rise in support of the bill, but I also rise as the chairman of the Committee on Appropriations to say that my support should not be considered as precedent-setting of allowing committees to just add appropriations to their bills. They have to first clear through appropriations. So I have no objection to the appropriation. In the interest of special circumstances, this being the day after Memorial Day. But I want to make, the Office of Finances and Budget has submitted a proposed amendment to clarify things. One, it wanted to make sure that we are clear as to who it's supposed to go to. The appropriation goes to the Department of Land Management, and it makes clear where the monies are supposed to be coming from. And so the amendment that I passed out to all the members is written by the Office of Finance and Budget to make sure that we effectuate the intent that the author of this bill wanted to have done. I didn't want to have any problems when we passed it. I want to support our good chairman of Veterans Affairs and to make sure that we properly fulfill our obligation to our veterans in providing for them the best possible and the burial sites that we can find for them. And so we have no objection to the amendment. We just wanted to clarify it to make sure that there's no issues after we pass the legislation. So this is my proposal.
So your
or the
amendment,
proposal by OFB to make sure that there's no issue with the appropriation language.
so Mr. Vice Speaker, then your amendment then would be to replace the 5 with this amendment.
Yes, ma'am.
Okay, so on the amendment by the Vice Speaker, no objection, so ordered. On the motion, is there anyone who would like to speak on the motion? Senator Abbott, do you want to close?
Thank you, Madam Speaker. And I certainly want to thank the chairman for the Appropriations Committee for the amendment that he has made. It certainly has made it very clear as to where the funds are going to come from and who it's going to go to. And I thank him for that. And I would ask that the chairman for the Committee on Appropriations, the Vice Speaker, be added on as a first co-sponsor of the bill. And I know that we've already passed the resolution also. I mean, it's already gone down. I don't know how we fix that, but I would like to make him the first co-sponsor. And I say that because it was really through his intercession that allowed me to get these first 2 documents on the agenda, despite the fact that there were other bills that really should have gone on if we were going to go in numerical order. So I would ask that in Bill 92, the Vice Speaker be made the first co-sponsor, and I'll figure out later how we can do that on Resolution 83.
On that motion, then, without any objections, so ordered. And on the motion to send,
Yes. Well,
one moment, because legal counsel is conferring with the author, so I want to make sure before I send it down.
outside of law. Yeah, yes.
Tom, I need a trash can. Because I can't throw this in. So Senator Abbott, nothing about the bill then? So on the motion then to send 92-33 LS to the third reading file without any objections, so ordered. Bill number 90-33, Senator Munya Barnes, you're recognized. Senator Munya Barnes?
Madam Speaker, I move that Bill 90-33 LS be moved to the third reading, and if I can briefly speak about it.
You may proceed, Senator.
Madam Speaker, 90-33 LS is an act to approve Track 9, Block F, Lot 14, Barragata, with an area of 10,049.75 square meters, has a suitable lot relative to effectuating a land exchange between the Department of Public Health and Social Services and the Chamorro Land Trust Commission for the purposes of constructing a foster care facility pursuant to Public Law 32-226. Madam Speaker, pursuant to that law, there was a section of that public law that gave the authorization for this august body to introduce a resolution. We did work on that resolution, and it was passed. And as I understand, we just want to make sure with this bill that we codify it and put it in statute as it relates to property, land, and just assuring the community that if there was any kind of question, that we know that a statute is in place. There is also another provision on this, Madam Speaker, which is a portion of that talks about the construction of the foster home. If it doesn't commence within the 3 calendar years of the enactment, then this Barragata tract will revert back to the inventory of the Chamorro Land Trust Commission. And as collaborated with my colleagues, I had no objections to that, and that was included. So I asked my colleagues to just give this favorable consideration. I will note that based on the timeline of the documentation and the request coming from Chamorro Land Trust, that there was a timeline on this as submitted, and that timeline was on May 21st. But I want to still ask my colleagues to work with me on Bill 90-33 to assure the community that this is the true intent, and again to add that provision if that foster care is not built. So thank you, Madam Speaker, for giving me the opportunity briefly on this bill. Sijos Masi.
You're welcome, Senator. On the motion then for 90-33, is there anyone who would like to speak on it? There being none, so the motion to send 90-33 LS to third reading file without any objection, so ordered. Bill number 15-33, Senator Munya Barnes, you're recognized. Oh, yeah, okay. Okay. McCready's not here. Mr. Vice Speaker, on Bill 31-33.
Thank you very much, Madam Speaker. Madam Speaker, I ask that Bill 31-33 be placed in the third reading file, and I ask for a short opportunity to speak.
One moment. It's not substituted?
No, ma'am.
Okay, so you may proceed, Senator.
As reported out by the committee, it was not substituted.
As reported out.
Thank you very much. Madam Speaker, last year I'd asked the public auditor to do an audit of the hotel occupancy tax. Just before Christmas, she issued her audit report, and in it, she lamented the fact that the Department of Revenue and Taxation was unwilling to cooperate with her office in allowing her to view the documents that she needed to be able to complete her audit. It seemed there were two divisions within the Department of Revenue and Taxation, and each one referred to the hotels differently. One used numerical numbers, one the other used alphabet. And they were not able to give the names that were attached to the numbers or to the alphabet. And so the auditor was unable to compare them to see whether or not that A was 1 or B was 2. They weren't able to do that. And Revenue and Taxation said they refused to do that. As a result, she issued an audit which was incomplete, and she said, I can't do my work because I'm not able to review these documents. As a result of that audit, I introduced Bill 31-33. And in it, I just wanted to clarify something, because as I understand it from the public auditor, when she first started as a public auditor 15 years ago, the Director of Revenue and Taxation at that time allowed her free access to look at documents for the filing of the local taxes. And I want to stress that, Madam Speaker. The local taxes that we pass, the business privilege tax, the hotel occupancy tax, the property tax, those things. Never has Revenue and Taxation violated the federal statute by allowing the auditor access to Internal Revenue Code tax refunds. They're both very good about that. But lately, the Director of Revenue Taxation has not been allowing the auditor access. I think you saw the other day, I think the day before yesterday in the newspaper, there was a news story about the fact that she was asking the Attorney General's office for a legal opinion as to whether or not the auditor should be allowed access to view tax refunds. I mean, not tax refunds, the tax credits for Luzon and for tax credits in general. Because, again, one of the members of the legislature, besides myself, I think, because I know that others have asked, but had asked that she do an audit of the tax credits. And she just issued a release audit last week. And in it, again, she was unable to complete her responsibility to the people of Guam to produce an audit where she could say, I have compared everything. I'm assured that all the documents that I have before me, I was able to reference and cross-reference. She was unable to do that because, again, Revenue and Taxation refused to allow the Office of the Public Auditor that access. This is a very simple amendment. It just says, nothing in this section shall limit the ability of the public auditor to access tax returns and other information required to be filed or furnished by the taxpayer in the administration of his duties, unless such information is specifically privileged by the Internal Revenue Code of the United States. It's very clear that the Internal Revenue Code documents are not and should not be accessible to her. And so this is a very simple amendment. Madam Speaker, I understand that some of the members of the legislature may have been contacted by the chamber asking for a short amendment. And if you just give me just a second, Madam Speaker. No, I'm not going to make the amendment. They asked for an amendment, and it's unnecessary. They asked for a language to be put in as long as the information is restricted from being divulged against any specific oath taken by the public auditor and his staff. And, Madam Speaker, that is unnecessary. Currently in the code that created the public auditor in 1 GCA 190901, and I'll read the entire thing into the record so that the chamber understands and my colleagues understand the reason why I'm not making the amendment that was requested by the chamber. It reads, except pursuant to a subpoena issued by the court of competent jurisdiction for good cause shown, or the powers afforded the legislature under legislative and investigative powers, the public auditor shall not be required to disclose any working papers. For the purpose of this section, quote, working papers means notes, internal memoranda, and record for work performed by the public auditor on audits and other investigations made pursuant to this chapter, including any and all project evidence collected and developed by the public auditor. Please remember that it says, shall not be required to disclose to anyone. Section B reads, information received by the public auditor alleging criminal activity or alleging wrongful use of government funds or property is privileged. Neither the public auditor nor any person employed by the public auditor shall disclose the identity of the person providing that information unless such failure to disclose infringes upon the constitutional rights of the accused. Nor shall the public auditor or any person employed by the public auditor be required to produce any records, documentary evidence, opinion, or decisions relative to such privileged communication or information. Subsection 1. In connection with any criminal case, criminal proceeding, or any administrative hearing of whatever nature, or 2, by any other discovery procedure. C. Any person arrested or charged with a criminal offense may petition the court or for an in-camera inspection of the records of a privileged communication or information received by the public auditor and which is material to the criminal charge brought against that person. The petition shall allege facts known showing that such records would, 1, provide evidence favorable to the accused, 2, be relative to the issue of the guilt. 3, cause a deprivation of a constitutional right of such communication or information is not disclosed. If the basis of such criteria the court determines the person is entitled to or any part of any such records may order its production and disclosure to the degree necessary, protecting the extent possible the identity of the person who has informed the public auditor of such matters. D, and this is the important part, Madam Speaker. D, disclosure of privileged communications. Disclosure of privileged communication or privileged information is a violation of this section shall be a felony of the third degree. It would seem to me that's plenty more, if there's such an English verb, there's a lot more protection than as long as information is restricted from being divulged against any specific oath taken by the public auditor and his staff. The statute is replete. I spent 10 minutes reading it and half a minute reading the three lines that they wanted. And it ends with disclosure of a privileged communication or privileged information in violation of this section shall be a felony of the third degree. The amendment requested by them is unnecessary. So I ask my colleagues, please, I understand you've all been approached for an amendment. I assure you that the code section within the public auditor's enabling legislation is sufficient. It even makes it a third-degree felony. The very simple amendment that I've asked for, nothing in this section shall limit the ability of the public auditor to access tax returns and other information required to be filed or furnished by the taxpayer in the administration of his duties, unless such information is specifically privileged by the Internal Revenue Code. So as I've tried to explain to the chamber members when they came to my office, I am not asking to give the public auditor access to Internal Revenue Code tax returns. There is nothing I can do in this legislature to give them that authority. This legislature has no authority to override federal statute which prohibits its disclosure. I would not exercise that kind of futile effort. I am just asking that the public auditor that we have created be given the authority to access information for taxes we as a legislature have passed. The business privilege tax, the hotel occupancy tax, the property tax, and if we give credits, the tax credits. That's all I'm asking. Not asking for anything in the Internal Revenue Code. It's specific in the provision that I've provided in the amendment, and the code that creates the public auditors explicitly prohibits anything from being divulged. As I tried to explain to the chamber, actually, if I wanted to, or any member of this legislature wanted to, we have the authority by statute to impanel an investigative committee, and we can ask for that information. I have told everybody, I don't want to know that information, the names. I just want the public auditor to be able to go through and assure me, assure us, assure the people of Guam that the books match the books balance. There is no need for it to get into this political arena, for an investigative committee to insist that the only way that we're going to be able to get the tax credit information is to impanel a investigative committee. That would set dangerous precedent that even I'm not willing to breach. So all I'm asking is please give the Office of Public Accountability the authority that we created it to do. Thank you, Madam Speaker.
You're welcome, Mr. Vice Speaker. On the motion, there being none, so on the motion to send, Senator Espaldon.
Thank you, Madam Speaker. Madam Speaker, I understand and I appreciate the effort to that this bill would provide the effort by the Vice Speaker in getting the information to the public auditor to be able to do her job so that she can provide us the information. However, again, there is concern. We all know that there is concern by the private sector on certain issues, and the Vice Speaker very aptly pointed to the Guam Code annotated, which basically does not allow just for an overall, let's open up the books to anyone, everybody, and disclose information. There are definitely limitations that are placed upon the Office of the Public Auditor subject to the internal code, Internal Revenue Code. If I might just ask, Madam Speaker, because he did read, and I did read it previously, perhaps not with a fine-tooth comb, but under Title I, yes, the responsibilities of the public auditor. The Vice Speaker did read it to us. However, again, as I was listening, there were a few points that I just kind of picked up on, and some of it is just a matter of the verbiage, Madam Speaker. In fact, one of the things that I took note of, and I just need to read it in its context, is something to the effect, shall not be required. And that little phrase in itself means that nobody can come and ask her or require her to do something. However, it still seems to be that that's more of a discretionary language by the auditor. And I'm not sure, Madam Speaker. So all I'm asking for is perhaps a minute or two recess so I can read the code that he cited and he read, and a little fast for my comprehension ability, but to be able to take a look at the code one more time and relative to the responsibilities of the Public Auditor's Office, so that there is comfort that an amendment is not needed at this time. So if I may ask for a 1 or 2 minute recess.
Mr. Vice Speaker, can you just give us the code section? That would help. So others also who have their own laptops might be able to look for it.
I'm sorry, I read too quickly. It's Title I, GCA 1909.1, Confidentiality of Investigations.
Okay. Thank you very much. So we're going to take a brief recess.
Thank you.
Session, we recess with Senator Espaldon. Were you able to then?
Yes, Madam Speaker, and I
to-
thank you for that time to read and reread the Guam Code relative to the Office of the Public Auditor. And in fact, in general, for the most part, I definitely support this legislation because I understand that, you know, the trials and tribulations the public auditor has had to go through and still not be able to get the information that's necessary to inform us on the financial conditions of our own government. And I think it's very important. That's exactly why we created that office. There were a few concerns, and I was able to speak with the mover of this bill, the good Vice Speaker. And at this point, Madam Speaker, I would like to not necessarily give up my time, but I would like to step aside, and I believe there may be an amendment coming that will, and then we'll speak at that time, if I may, Madam Speaker. Thank you.
Okay, so I will then recognize Mr. Vice Speaker.
Thank you very much, Madam Speaker. Madam Speaker, the email that I got from the Chamber yesterday was they wanted to include the language, as long as that information is restricted from being divulged against any specific oath taken by the public auditor and his staff. It was, I won't say anything. I've circulated what I think is even stronger language to make sure. Add at the very end, any information provided to the public auditor or any person employed by the public auditor under this section shall be considered quote unquote privileged pursuant to 1909.1, I think it's 1, not 11, 1909.1 GCA, 1 GCA 1909.1, disclosure of privileged information or privileged communication in violation of this section shall be a felony of the 3rd degree. It's 10 times stronger than their section, and I'm willing to do it just to get the public auditor the authority and the ability to do what she.
Thank you very much, Mr. Vice Speaker. So Senator Espaldon, with that new amendment, do you want to speak on the amendment?
I just want to rise in support of the amendment and as a consequence rise in support of the bill. And again, the Vice Speaker got it right the first time, that it's really already in the code right now. However, by the wise words of some of our predecessors in this body, sometimes redundancy is important. And again, this does assuage some of the concerns that members of the private sector do have, but to reiterate, I believe that the Vice Speaker got it right the first time in pointing to Title I and the parameters in which the public auditor can operate. So with that, I do support this amendment. Thank you, Madam Speaker.
You're welcome. On the amendment, anyone else? No objections to the amendment, so ordered. And now on the motion to send Bill 31-33, the 3rd reading file without any objections, so ordered. Thank you, Senators. Senator McCready, you're being recognized then for Bill number 21-33.
Thank you, Madam Speaker. I'd like to make a motion to send Bill 21-33 to the 3rd reading file, and I'd like to discuss.
You may proceed. Oh, wait, one moment, may I just double check first? It's been as reported out by the committee, no amendments?
I'm sorry, as substituted by the Committee on Early Learning.
So as substituted then
Yes.
by the committee, yes. You may proceed, Senator.
Thank you, Madam Speaker. Madam Speaker, I just first want to thank the Attorney General for facilitating this bill and just asking me if I could introduce it last term. Well, we introduced it last term, and it was kind of late in the term, so it didn't get anywhere. So we reintroduced it this year. And thank you to the chairman, Underwood. We were able to not get what we asked for in the entirety of the bill and the language, but we actually vetted this through all the departments and all the stakeholders that would be involved in making decisions. And we came up with a substituted version, which I think makes sense. I know there are going to be some more amendments to this bill, which I also agree with. There were some concerns brought up by some of our constituents in the law field. So there's going to be some other amendments. Also, the title. I was talking to my good friend, colleague, Senator Torres, and the title is the Juvenile Justice Reform Act of 2015, and she was right. This is a step towards juvenile justice and a step towards restorative justice. It's not the
Point of order, Madam Speaker.
Please state
I'm
your
sorry,
point of
Senator.
order.
Point of order, Madam Speaker. In the committee report, there are two substitute bills that were addressed, and I just need to understand. We all need to understand which substitute bill are we talking about.
That was the question asked earlier, as reported out by the committee.
As reported out.
Senator Respicio?
Yeah, Madam Speaker, I could provide some information. Senator Underwood was very diligent to show the evolution of this bill. So one version is the markup version, and then the other version is the substitute version that Senator Underwood reported out. So you would follow the substitute version and not the markup version, which is clearly labeled on the document. So there's no two substitute versions. One is her markup, and then one is her substitute.
So the markup then for members, if you look at the bill, you see the lines, of course, striking out, then that's the markup. And then the substituted version, the second substituted version of the version itself is a clean bill without the strikeouts. So, Senator, were you able to find it then?
Can we take a quick recess, Madam Speaker, so I can answer
Okay,
that
a
question?
brief recess, and to make sure everyone has a copy of the corrected substitution. Session, Senator McCready. We will continue then with the correct substituted version of 21-33.
Yes, this is, I think we answered the point of order or point of information from Senator Espaldon. This is as substituted by the committee.
So to be clear then one more time, is that
This is the clean version.
The copy that everyone should have basically is a clean copy, no
Yes.
strikeouts.
Yes.
And it starts at the very beginning at the top, an act to add. Okay, so you may proceed, Senator.
Thank you, Madam Speaker. And so I just want to commend the chairwoman on the committee, because basically what the new substituted version of Bill 2133 reflects is the public hearing. And so we vetted this process, we went back and forth, and we tried to give the most responsible bill that we could possibly legislate onto the session floor this morning. And so that's what we have here today. We have a bill that add 5106D of Chapter 5, Title 19, Guam Code Annotated. And as I said earlier, the title is to be the Juvenile Justice Reform Act of 2015. But when you think about it in general, this is just a small step. So I know that there's going to be an amendment to change the title, which I'm fine with. I just want to say that this is an attempt to make sure that we rehabilitate the offenders that are rehabilitatable. And this is a small step in that direction, but this is an absolute step that we need to take, because the Attorney General's office, the judicial system, the public defenders, all these stakeholders are on the same page when it comes to rehabilitating our juvenile offenders. And this is something that I hope we can accomplish. So I hope that I get the support of the colleagues. This is a bill that the Attorney General's office has been asking for, and I think we should give it to them. And I look for, great dialogue on the floor this morning. Thank you.
On the motion? Senator Torres, I heard you may have some amendments, and I don't have anybody else that's, so yes, you are recognized. Thank you, Senator.
Thank you, Madam Speaker. Madam Speaker, as we were listening to the presentation through the public hearings by the good author of this legislation, he mentioned that the inspiration for this bill was the State of the Judiciary address that was delivered in May 1st of 2014 by our Chief Justice. And I want to note that in the Juvenile Justice Reform Act, a call to action that was noted by the Chief Justice in his State of the Judiciary address, he described 4 focus areas. And the 4 focus areas have to do with evidence-based practices, juvenile court referral processes, juvenile defense and prosecution, and court language. And I believe that the good author of this measure had every good intention of addressing some of those things. But I think, however, Madam Speaker, that the title may be a little premature to consider it and cite it as the Juvenile Justice Reform Act of 2015. So I'd like to propose that we amend the title to delete from the last 2 lines the words "which may be cited as," quote, "the Juvenile Justice Reform Act of 2015," unquote. Thank you, Madam Speaker.
That amendment to delete, no objections? So ordered. Thank you, Senator. You still have the floor.
Thank you, Madam Chair. I think that when we look at the intent of this legislation, what we have to remember, and the good author alluded to the fact that the key here is rehabilitation and treatment of these children. And if the government feels that they cannot benefit from such, then they can petition to certify these children as adults in certain cases. I think, though, that in looking at the section 5106, I believe it's necessary to go back to section 5106A, subsection A, and provide some further amendments to that. And so what I'm going to proffer is an amendment to section 5106A that will only strengthen the intent of the new 5106D. And specifically what I'm referring to is, if you look at 5106A, it already provides for a certification.
Senator, if I may, because none of us have the A, so and if you have your amendment and it's ready, what we'll do is we can have copies then provide it to everyone so we can follow along with you.
Okay. I'm not going to discuss the amendment specifically, but I'm
Yes,
just
you're right.
alluding to the...
I'll definitely come back to you, because I don't want to confuse everybody.
Okay.
But I mean, we do have it, it's just that it would mean going back to the other copy, the substituted one that's stricken out, that
Right.
you're talking about, so there'll be another amendment, then you're going to have to offer to bring that forward. So we're going to take a brief recess so we can make sure everybody's on the same page, okay?
Thank you.
Thank you. The legislature is back in session. Senator McCready, on your bill, there's set aside, and we're going to set it aside, and then I'll pick it up on. Oh, that's it then? Okay, so we'll set it aside, and then we will.
If no
I know.
one's-
I mean, Senator. Okay, wait. Senator Torres, you have the floor, and I'm going to go on your decision whether there is going to be further amendments or not.
Okay,
Senator.
thank you, Madam Speaker. In our recess, I had time to go back to the author of the bill, and I believe that the amendment that I proposed perhaps would be better addressed in a separate piece of legislation. So I will not be making an amendment to this bill as I originally indicated. So I would withdraw that intention.
Okay, thank you. So then, on the motion now to send 21-33 to the third reading file, if no one here wants to speak on the motion, there being none, then 21-33 sent to the third reading file. Okay. Senator Espaldon, Bill 44-33, you're recognized.
Thank you, Madam Speaker. This is actually a very simple bill, Madam Speaker. Back, I believe it was the 29th or 30th Guam Legislature.
On the motion?
I'm sorry, I moved to send Bill number 44-33 COR down to the third reading file, and I'd like to speak
And is it a
briefly.
substituted bill?
It's as substituted by the committee, Madam Speaker.
Okay, so it's as substituted by the committee, so you may proceed, Senator.
Thank you, Madam Speaker. Madam Speaker, back in the 29th, it may have been the 30th Guam Legislature, I introduced a bill that created, with the help of this body, and we enacted into law, a law that would allow for prison industries. And it was a chance for the Department of Corrections to create within its systems rehabilitative type processes in which the inmates and detainees up there could perhaps
We're talking 44-33 is on credit history.
Oh, I'm sorry. Excuse me, Madam Speaker.
You're
I
jumping.
was
Yes,
thinking of
I was wondering.
number
I said,
7.
wait a minute.
I'm sorry, Madam Speaker. I was geared towards. If I may set this aside, and I'll speak to it later, Madam Speaker.
Okay, sure.
Thank you.
Senator Respicio then on 69-33. Yes, Senator asked to set aside. (69-33).
Thank you very much, Madam Speaker. Madam Speaker, I move to place Bill 69-33 as amended by the author in the third reading file with some brief discussion.
You may proceed, Senator.
Thank you, Madam Speaker and colleagues. This bill is an act to amend certain sections of the code relative to the Guam Department of Education's use of Easter and Christmas breaks as make-up days in the school calendar. And I want to begin my presentation on this bill to recognize and thank our Oversight Chair, Senator Underwood, for facilitating this bill through her committee, but more specifically through the legislative process. When I first introduced this bill, Madam Speaker, and Senator Underwood as a co-sponsor, we had an active discussion about whether or not the introduction of this bill would usurp the authority of the school board, who is really tasked by statute to determine 180 instructional days, and that's set by law. And so she and I both said, and she said herself, given her current, her former capacity as superintendent of education, that we just have to go back to the premise that if the 180 days was set by law, then certainly only an act of the legislature and the governor's concurrence will amend that. So we introduced this bill primarily in response to giving voice to the concerns raised by students and teachers and parents of these students, that to set aside Easter and Christmas break and then to not have an idea whether or not these days are going to be used, only to know days before the actual breaks, we know that families have had to rearrange their travel schedule, and so teachers have had to not only rearrange their travel schedule, but if they couldn't do so, they would have to use their own day set aside if it's personal leave, and if they don't have that personal leave, they end up going leave without pay. And so this issue also gave rise in the last Easter or spring intercession, where you had all the public school students come in for the first day of Easter break, and then there was a water outage at Audit Elementary School, and that school community had to come in for a second day from their Easter break. And so when we introduced this bill, certainly there was some in the community that said, why is the legislature meddling with something that the board should be doing on their own? Well, I attended a work session with the Board of Education and the superintendent and the deputies of superintendent. And so after that interaction, Madam Speaker and colleagues, the board finally accepted, and they realized that they need this bill to continue to give them the authority they need to determine these instructional days and to do things differently other than just the 180 instructional days. And as a result of that exchange, they proposed an amendment on page 2, line 7, to add in the words or its equivalents, including makeup days. And so when the board came back to us and said this is what they would like to see the bill amended as, I want to thank the Oversight Chair, Senator Underwood, for allowing me to present an amended version even before the public hearing was called on this bill. And so what that did is that caused all of us to be on the same page from the moment Senator Underwood announced that this bill would be publicly heard. And so some of the things that the superintendent and the board are thinking about with respect to Bill 69 is if you have to provide for a makeup day, you don't, and you include instructional or its equivalents, including makeup days, then you can do things probably without having to call the teachers and students into school physically. They've talked about providing what they do in the States with, they have blizzard kits. In our case, it'll be storm kits where students are provided some kind of an assignment, and if a certain percentage of the school community respond, then they would not have to make up that day. They also had some other ideas to go ahead and add days after the school schedule, so that if they need to tap these additional days, they would go at the end of the school schedule. But if they don't, then students will have to be let out earlier. So you would be within the parameters of this 180 instructional days or its equivalents. And so what I'm pleased to report to all of us this morning is that this bill is really being supported by not only the Board of Education, the superintendent, but also the Guam Federation of Teachers Union, because they all recognize, and the boards even said that they've never believed that it was ever the intent of this bill to usurp their authority, but rather use it as a vehicle to give them more authority and more flexibility, ultimately recognizing that they cannot use Easter and Christmas breaks, and this will provide for more regularity in the planning process, not only during these holidays, but also as we approach the summer months. And so the boards asked that this legislature address this bill, so if it meets the governor's acceptance, they can begin planning for next school year, and so that the students, the families of these students, and more specifically the teachers and employees who are affected by this policy will no longer have to worry that when they plan for a vacation during these two holidays, that there would be concern that they may have to reschedule, not go, or in some cases go, and then they would have to face having to pay for their own leave if they don't have any personal leave. So thank you, Madam Speaker.
You're welcome, Senator. On the motion, Senator Spaldon.
Thank you, Madam Speaker. I understand what the bill is trying to do. I do have a question in terms of the wording of it, and if I may ask the mover of this bill a question, if he would allow.
So you may proceed with your question, then I'll ask the Senator to yield.
The question is, bottom line, it says in-law has right now subsection M, at least 80 instructional days, and then there's an underscore, or its equivalents, including makeup days. I'm not sure I understand or its equivalents means. if I could just get a clarification what that might mean. 180 days is 180 days, and I'm not sure what the equivalent would be.
Okay. Senator Respicio, do you yield to the question?
Senator, for that question, or its equivalence would mean instructional minutes. And so they would do instructional days or its equivalents, and so instead of being tied down to the number of days, they would determine how many instructional minutes are required in order to fulfill those instructional days. And so when you also say including makeup days, this is where the board appreciates this idea that they're going to have more authority, more flexibility, because like I've said, they could provide for storm kits where they provide some kind of assignment where if a percentage of the students respond to that assignment, then the board can deem that instructional day or its equivalence is not necessary, and so the makeup day could be part of the 180 days. Right now, their hands have been basically tied, and it took Senator Underwood and I going back to the board to explain to them that they should be concerned that the current statute does not give them the flexibility that they need in order to provide for these makeup days. And so there's many examples of how these days can be made up. They can add minutes to the day. They can add 5 minutes, 10 minutes per class. And so that will, if you calculate everything, that will be equivalent to a day. Superintendent Fernandez was very clear with us that he's been brainstorming this issue with his lawyers to see if there's any way out of providing for additional minutes to each class, but their lawyers are saying based on the current statute and the current reading that it's 180 instructional day, they couldn't do those kinds of creative ways to preserve the statutory requirement to require that our students have 180 instructional days or its equivalents.
Thank you, Madam Speaker, and
Senator?
thank you to the
Yes,
author.
right.
That does
Proceed.
answer my question.
Okay.
Thank you.
You're welcome. Is anybody else who'd like to speak on the motion? There being none, so on the motion then to send 69-33 to the third reading file. No objection, so ordered. Senator Espadon, are you ready for your 44? Or
Thank you, Madam Speaker. Yes. Madam Speaker, this is Bill number 44 as substituted by, I move to place Bill number 44-33 COR as substituted by the committee down the third reading file.
and you want to speak
And
on it?
if I may just have a few words, Madam
Okay.
Speaker.
You may proceed, Senator.
Madam Speaker, this bill is an act to add a new subsection H to section 5201 of 22 GCA relative to the use of an individual's credit history in the employment process. What we're finding out, it's not a glaring problem right now on our island. However, that being said, from the research and the readings that we've seen of what's occurring in the United States across the country, that there's more and more incidences where employment applications or employment applicants are being turned down for the job regardless of their ability, but basically they're being turned down based upon their credit history. And there are many jobs, Madam Speaker, that do not, I believe, that do not really require these potential applicants or these applicants to be eliminated from consideration just because they have had or have poor credit history. We have people in the private sector working at the hotels, bellboys, waiters, and whatnot, again, where the credit history, I don't think, has any relevance to the position that they're applying for. So this, in essence, all this does is limits the ability of an employer to use the credit history as a condition for being examined as an applicant for the job position that might be advertised. And basically the subsection H, and I'll read it in its entirety so that anybody who's listening might have better understanding. And it says, for any employer to use the circumstances of an individual's credit history as a reason for denial of employment or as a reason for termination of employment unless the circumstances are substantially related to requirements of a particular job or license activity. An employer may request a credit history background check as part of the application process where it is shown to be directly related to the position sought by the applicant under at least one of the following circumstances. One is the position requires bonding or other security under state or federal law for an individual holding the position. Two, the position is managerial and involves setting the direction or control of the business. Three, the position meets criteria in specifies federal or state administrative rules to establish the circumstances when a credit history is a bona fide occupational requirement. Four, the duties of the position involve access to customers, employees, or the employer's personal or financial information other than information customarily provided in a retail transaction. Five, the duties of the position involve a fiduciary responsibility to the employer. Or six, and this is where we made the amendment, the position includes an expense account. Any employer who chooses to use an individual's credit history as part of the hiring process or an individual's credit history as part of the retention process shall disclose this fact to the individual, comma, and this is where we made the addition, and shall obtain consent from the individual prior to requesting a credit history background check. The employer shall follow all the legal rules set out in the Federal Fair Credit Reporting Act for any subsequent determinations or actions taken as a result of information contained in an individual's credit history background check. Subsection 1 is for the purpose of this subsection, the term fiduciary responsibility shall refer to a relationship in which an employee has a responsibility of care for the property or funds of the employer. Now, the reason, Madam Speaker, although it may seem innocuous and non-relevant to a lot of people, we just don't want the use of credit history to determine whether a person is really qualified for any positions other than those that were mentioned in the above section. And we know on Guam that there are many instances where good people, good, hardworking people, have fallen into situations where their credit history was damaged, whether it because after a typhoon they've had to expend a lot of money just to repair their homes and whatnot, and had fallen behind on some of their payments, or whether because of the medical circumstances that many families face and on this island, and then basically fall behind on some of their obligations and payments, and thus their credit history is ruined. But these are good, hardworking people who are just trying to survive. So this measure just basically protects individuals who are not in fiduciary positions from having to be denied or employment or terminated from employment because of their credit history. Thank you, Madam Speaker.
You're welcome, Senator. On the motion, Senator San Nicolas, you're recognized.
Thank you, Madam Speaker. I follow the logic of the author of the legislation. Just some suggested amendments, and maybe if I can get some feedback as to whether or not they would be problematic. But on page 2, line 19, after the word obtain, add the word written. And this is so that it says shall obtain consent from the individual prior to requesting a credit history or background check. And I would probably request that we require it to be written consent. That way there isn't any confusion as to whether or not the credit report was acquired by the employer with the consent of the applicant.
On the amendment?
Madam, I believe that's a good amendment. I rise in support of that amendment.
So no objections to the amendment? So ordered.
Thank you, Madam Speaker. And then also a final suggestion is on page 2, line 25. The whole section there, the subsection there that's being added, says, for the purposes of this subsection, the term fiduciary responsibility shall refer to a relationship in which an employee has a responsibility of care for the property or funds of the employer. I want to add after the word employer, or its customers. Because sometimes a fiduciary relationship, you may be, for example, working at a bank, you are a fiduciary not only of the bank's assets, but of the customer assets in the bank.
On the amendment, no objection, so ordered.
That's all, Madam Speaker. Thank you.
Very welcome, Senator. Is there anybody else who would like to speak on the motion? So on the motion to send 44-33 to the third reading file, Senator Spaldon, I'm waiting for you because if you have anything,
I'm sorry, Madam Speaker.
before I send it down, I want to make sure that you either.
If I may, Madam Speaker, I'm consulting with legal counsel right now. She
Okay,
has an
so
issue.
take a brief recess.
Thank you.
Spaldon, then on the bill to close.
Madam Speaker, if I may, after consulting with the legal counsel, I would like to make one last amendment, and that would be on page 2, line 17, beginning where it reads the new sentence, any employer who chooses and to use an individual's credit history. What I am moving to amend is that any employer who chooses, and then add the words consistent with this subsection, chooses, comma, consistent with this subsection, comma, to use an individual credit history. And again, it was more just for, I believe, a tightness of the law as according to the legal counsel. And so I move that as an amendment to this bill.
On the amendment, no objections? So ordered.
Thank you, Madam Speaker.
So on the amendment then to send 64-33, I'm sorry, 44-33, the third reading, no objections, so ordered. Bill 64-33, Senator Morrison, you're recognized.
Thank you, Madam Speaker. Madam Speaker, I move to place Bill 64 as amended by the author of the Committee on Finance and Taxation, General Government Operations and Youth Development into third reading file. And I'd like to briefly speak on it, Madam Speaker.
You may proceed, Senator.
Madam Speaker, Bill 64 as amended seeks to address concerns raised by the Mayor's Council of Guam during a public hearing on the measure. Those issues which have been addressed in the amended version as reported out by the committee include the following. First of all, I also like to thank the Chairman, Madam Speaker, for further expanding on the roundtable discussion that helped to allow for stakeholders to provide some input. The Council recommended that the legislation expand on the use of broadband internet services or access to other public facilities under the control as designated by village mayors, such as gymnasiums and senior citizen centers, which are used at times for adult education courses and other special programs. Section 4302 of the proposed article in the bill addresses this issue, Madam Speaker. The Mayor's Council also recommended the bill be required that the Council and not each individual Mayor Council be responsible for determining the policies, terms of use, and conditions for access of internet access at village community centers be at designated public facilities. Bill 64, as amended, further incorporates recommendations made by the Legislature's Legal Counsel regarding posting of guidelines. Section 4305 of the proposed article in the bill require that the Council do develop posting guidelines to be uniformly applied to all mayor's offices and other designated public facilities. Such guidelines shall protect against advertising religion, political activities, weapons, drugs, tobacco products, alcohol, or other products or services that are inappropriate for educational purposes. Another issue was raised during the public hearing regarding the costs involved with authorizing the solicitation and acceptance of broadband internet services. To clarify, Bill 64 intends to authorize the donation of such services at no cost to the government of Guam, so that our youth and families that own these devices, such as iPads, smartphones, laptops, or other devices, can connect to Wi-Fi and may avail themselves to free internet services. A concern also, Madam Speaker, that was brought up by our mayors is that they may have to hire more personnel in order to implement Bill 64. I disagree, Madam Speaker, and so does the Mayor's Council, as they carefully read through the bill once more and have a better understanding of the intent of the measure. As stated, Guam's mayors welcome the level of interest expressed by 3 major telecom or telecommunication providers, including Docomo Pacific, GTA Telecom, or Teleguam, and IT&E, to donate free broadband internet services. And finally, Madam Speaker, Bill 64, as amended, intends to provide the legal authority to Guam's mayors to solicit and accept donations or free broadband services or internet services. As publicly stated by our mayors' councils, although several Guam's mayors or mayors of Guam have accepted donations in the past few years, the organization would like to ensure that they are given the authority to engage in this activity moving forward. This would also, Madam Speaker, prevent questions of special interest or favoritism. Moreover, Bill 64 seeks to ensure through Section 4304 of the proposed article in the bill that each mayoral office, the government of Guam, and the internet service providers are provided immunity from liability in accepting broadband services at no cost to the government of Guam. Thank you again, Madam Speaker, for the opportunity to briefly speak on this measure, and I ask my colleagues for their support. Thank you.
You're welcome, Senator. On the motion, is there anyone? Senator San Nicolas.
Thank you, Madam Speaker. I rise in support of Bill 64-33. Similar to Bill 9 that we'll be discussing later on today, the committee has worked very closely with the author to make necessary changes that would seek to further the intent of the legislation. So to clarify, there is already internet services being provided, but this bill will allow for the process to be more streamlined and transparent so that existing and future providers who want to participate in providing free internet services to their villages can do so with a clear set of guidelines. And these guidelines are not only what's enumerated here in Bill 64, but they also require the Mayor's Council adopt uniform guidelines for usage throughout their villages so that one municipality doesn't have one set of rules that's different from another municipality. I did want to, real quick, Madam Speaker, just credit Mayor Jesse Gogui from the municipality of Chalampago, who added some very key language that I wanted to just read into the record. He suggested that we add language that says, so long as these free services are provided without any written or implied conditions in the acceptance of these donations. And that's the end of his language that he proposed. We did include it in the proposed bill because he very astutely caught the likelihood that maybe a provider might donate services conditional upon the municipality buying another service. And so he wanted to make it very clear that if you're going to be receiving these as donations, that they are in fact donations and not gifts with expectations or some other due considerations required. So I wanted to just, for the record, thank Mayor Jesse Gogui for his contribution and thank the author for working with the committee so that we can finalize and report out a version of the bill that was ready for the floor. Thank you, Madam Speaker.
You're welcome, Senator. Senator Tom Adel, you're recognized.
Thank you, Madam Speaker. You know, I certainly rise in support of the bill, but I do have a question, and if the author would yield. On page 2 there, on line 20, it talks about, well, that particular section talks about access control. And the language is in there that the mayor's office will determine the hours of operation for wireless internet services at the community facilities and to refuse access to internet services to any person And maybe the author can yield. How do you refuse access to internet services?
Yes, Madam Speaker, I yield to the question.
Thank you, Senator, yes.
I thank my colleague for that question. That was brought up during our roundtable discussion that the Mayor's Council wanted to have this ability to refuse access. One measure that they'll provide is access codes, passcodes, keys that allow for our constituents or the community to access broadband service at these, once these Wi-Fi access are available at the centers. So I believe the concern would be that if someone was gaining control and using it for other purposes other than educational purposes or to communicate or to do work, I think it will allow the mayors to see if these folks were using it for purposes outside of the guidelines, that they will refuse the services. And I hope that I'm able to answer that question.
Well, actually, Madam Speaker, not quite, because I understand the part about if the individual is getting on the internet to, look at porn or other material that's really not intended for, I can understand that would be a basis for refusing it. But I guess my question is that normally when you go to a facility like this, then, if the mayor's office wants to change the password every day, then you pass it, and then when I come in, if I'm going to use it, it's okay, what's the password? And they give it to me. But otherwise, if the mayor's office doesn't give it to me, my friend sitting next to me is going to say, hey, sorry, the password is this. So how can we refuse? You really can't.
Do you yield to the question?
Again, yes, I yield to the question, Mr. Speaker. Again, as it states here, there has to be just cause to ensure that, and to refuse anyone in the first place. But I believe that it is our hope that we wouldn't have to refuse anyone from using the service. Our whole intent here is to have the community at their village, at the village centers or whatever facilities that it's designated, that our youth and families will have access to communications, using it for good purposes. But again, this was provided just in case there has to be a need that we have to refuse an individual that is using this for purposes other than what will be stated in the guidelines. Those guidelines will have to be crafted by the council and provided to the public prior to the usage of broadband services. So I appreciate my colleagues' concern. Of course, this happens at internet cafes. We do see the shared of passcodes here in our legislative body. We, of course, secure our keys because we know that it's for the purpose of the legislature and using it for the work of this body. So, again, I know this is a concern that we may all have, and I hope that the folks that will be using these services clearly know the intent, and that working with our mayors or the mayors providing these guidelines will make that very clear that this is what this purpose is for.
Thank you. And again, I understand, the basis for refusing services. I'm just saying, procedurally, there's no way unless you tell him, I don't want you within 50 feet of this facility, which is outside the range of the Wi-Fi. Then that way, you can actually then refuse use of that Wi-Fi, but at the same time, you basically, basically refuse them access to the facility. That's the only way you're going to do it. So the only reason why I raise that point is that then if we agree that you cannot, the only way you're going to refuse him access, if I walk in there with my iPad, the only way you're going to refuse me access to that Wi-Fi is if you keep me out in the perimeter a certain distance from the outside of the Wi-Fi range. And so it just kind of, really it's maybe on line 20 we should just, where it says to determine the hours of operations for wireless internet services at respective community facilities in their villages, and end it there with a period. And then strike out the words "and to refuse access to internet services to any person, provided there is just cause in the refusal of such service." Now, I'm not that technically proficient, in how do you refuse access. The only thing I know is that I can't log into your Wi-Fi even if I knew the password if I'm not within range. So I'm making the motion that then on line 20th on page 2, that sentence ends with "respective community facilities in their villages," period, and then strike out everything from "and to refuse access" to the word "service" at the end at line 21.
Is everybody clear on the amendment proffered by Senator Tom Abbott? Anyone wish to speak on the amendment? Senator Morrison.
Thank you, Mr. Speaker. I'm open to the amendment. I'm making this. There is, if we really want to get further into the technology, certainly, working with these providers, that there could be a possibility, if it's really that bad, that we have to refuse someone services at the community centers, that there's ways to block the IP address or block these folks with their devices out from accessing that service. But again, I'm open, and maybe regardless of the language, again, this was asked by the providers, by the council, that maybe even within their guidelines they can actually note that. So I'm not objecting it, I'm just open to it. If there's any further discussion that we can work with, but I'm not objecting.
Thank you. I saw Senator McCready's hand and then Senator Nicholas's hand.
Thank you, Mr. Speaker. Is this for the amendment or on the main motion?
On the motion proffered by
motion.
Senator Abbott.
The amendment proffered by Senator Abbott.
Yeah, yes. Okay. Senator Nicholas.
Thank you, Mr. Speaker. The purpose of this language is so that when the mayors develop their terms and conditions for using the wireless facilities, that if they wanted to create provisions to refuse access, they could. One that just jumps off the top of my head, Mr. Speaker, is maybe we want to refuse everybody who's on the sex offender registry from being able to access these wireless services. Maybe we don't want them to be able to bring a wireless device to an access point, and from there, that's provided by the government, and from there engage in whatever activities they might engage in that we wouldn't want them to. Now, there are ways, Mr. Speaker, to refuse access on wireless networks. Every device has an IP address, and so if those IP addresses are found to be connected with the individual who are trying to refuse access, those IPs can be banned by the server or whoever is operating the wireless network. I know that if, for example, in this hall, Mr. Speaker, if too many devices are accessing the network and slowing down the ability for senators to be able to download or receive documents or whatever, because the server is getting too congested, our network managers here in the building can boot off certain devices that are hogging up too much of the space. So there are ways, Mr. Speaker, for network managers to be able to go in there and kick out somebody who's on the system. I'm not too comfortable with the idea of saying that the mayors cannot refuse, because if there is a clear and present threat to the community, or if there's a clear and if there's a clear reason why they may want to refuse access for a constituent, maybe they misused the service previously, maybe they downloaded illegal or inappropriate material on the public server previously, they don't want them to be able to use the service anymore, then they need to be able to say, you know what, we're going to refuse you. And, I mean, in the example given that, oh, they got the password from somewhere else, you can probably post in the guidelines, do not give out the password. And if you are found to have given out the password, you also will be on the refusal list. So we can create a regulatory environment for this, Mr. Speaker, and I think we have to. Because if we're using public funds, or if we're using an act of public law to authorize for these services to be provided, we want to make sure that there is a way for the government to make sure that the services that are being provided aren't being used for illegal purposes, and if they are, then those who are misusing the service can in fact be refused. So I support this language being maintained in the section. The reason I had an issue with it when it was initially proposed was that the previous language was just a blanket ability to refuse. But the author, in working with the committee, allowed us to include the language that said that provided there is just cause in the refusal of the service. So the rules and regulations that are developed can't just allow for the mayor to refuse anybody because, you know, you didn't vote for me or you didn't come to my fundraiser. The mayor cannot refuse you unless the mayor has just cause. And so those will need to be adopted in the uniform guidelines the mayor's council will have to adopt pursuant to the entire section. And I think that it's something that we need to keep in the legislation, Mr. Speaker, so I would need to object to the amendment. Thank you, Mr. Speaker.
Thank you very much.
I thank the previous speaker, Mr. Chair, for clarifying some other options of how to address this. And I hope maybe we can have the author of the amendment maybe reconsider. I forgot to mention some of the technology behind of how we can also block these type of things. Is every individual could also be given their unique key password to, or unique, if that is the extent we have to go. So there is other measures, way to control that. If the concerns is about sharing passwords or codes. So there is a way to do it to unique keys. Just wanted to provide that information.
Thank you. Any other senator wish to be heard on the Tom Adda amendment? Senator Tony Adda.
Thank you, Mr. Speaker. And Mr. Speaker, with that being said from the previous speaker, then as to the controls and giving the mayor's option that the mayor's ability to control that and giving them that authority to refuse access, I would have to then object to the amendment proposed and keep that language in.
Thank you.
Then I second, I second that.
Anyone else wish to be heard on the Tom Adda amendment? Yes. There's been an objection. Senator Adda, do you wish to close? Okay. On the amendment, there's been an objection. All those in favor of the Tom Adda amendment to strike those two lines, please indicate by raising your hand. You object to your own amendment? Okay. The amendment fails. The amendment failed. Senator Addy, you still have the floor.
Oh, that failed, right?
Yes.
Thank you, Mr. Speaker. Mr. Speaker, I'm just trying to reconcile and understand better. On page 3, section 4305, authorization to solicit and accept donations. Now, if I understand it, I guess the intent here is to authorize the mayor to be able to go out, let's say, to one of the telecommunications companies and say, you know, hey, we'll put your banner up if you give us free Wi-Fi for our community center that the kids can come to and utilize it. To provide that Wi-Fi to, I guess, to solicit for that, and then the residents from the village can come and utilize that Wi-Fi for free. And if that is the case, on line 10 on page 3, it reads, notwithstanding the provisions of whatever that section is, each mayoral office is authorized to solicit and accept donations of cash, equipment, and services for the purposes of providing internet services. And so I can see authorizing them to go out and solicit for and accept donations for, the router, to set up the router, to whatever other equipment, and maybe to come in and provide whatever training services that may be involved in this whole thing. But I'm not comfortable with the solicitation for donations of cash, because then who's going to account for that? Now, there's something in here about that they do have to account for equipment that is received. The name of the donor, the date of the donation, and a description of donations with a value in excess of $100. Well, just give me $99 and we'll be fine. And according to this, you don't have to account for it. And so I'm just wondering then, if the idea is to get this free services from the telecommunications provider to be provided for free to the villagers, then why do we need to solicit for the donation of cash? And so my amendment is on line 11, is to strike the word of cash, so that then it would read, authorized to solicit and accept donations of equipment and services. Thank you.
On the added amendment to strike cash, Senator Blas.
Thank you, Mr. Speaker. Mr. Speaker, I raise in support of the amendment. I have another concern I guess we have with this is, while it provides the authorization to receive cash as a donation, unfortunately, there's nothing here that basically says, there is the procurement guidelines with regards to how you can be able to use the cash. And so I think that we're going to be looking into, it's one thing to be able to accept donations of the equipment, because the equipment and the services are bought, they're procured, they're done already. But when you get the cash, then you get into the whole issue with regards to how that cash can be legally used to procure the items. And there is no guideline and there is no mechanism to do this here. The assumption would be that they would have to go under the procurement guidelines, which could be a whole other mess. So I have to agree with regards to the deletion of the word cash. It does provide for a situation that may be problematic and would actually stymie and would actually go against the whole intent of what this legislation is.
On the amendment, as it relates to the word deletion of the word cash, I see Senator Torres and then the Speaker.
Mr. Speaker, I don't agree that we need to delete cash from the list of items that they're authorized to solicit and accept. If you think about the nature of the mayor's offices, they provide a whole lot of community services, and they are in the regular practice of accepting items and cash for certain events and for payment of certain events. So I think that in looking at the intent of this whole legislation, it's to provide free services to the community. And if that entails a donor or a benefactor making that happen for them, then I don't think that there's anything necessarily wrong or out of the ordinary as far as mayor's offices are concerned. And I think that because you have a value of $100, that is a very small threshold of disclosure. And I believe that it's not necessary to strike cash from this list. Thank you.
Madam Speaker.
Thank you very much, Mr. Speaker. Mr. Speaker, I support the amendment to delete the word cash, and I'll tell you why. Because there's no other entity, government entity, in which they're able to go in. I mean, there are many entities that are able to solicit. Cash, however, is something that's very different, but they don't fall under the purview of the government, where it says that any non-appropriated funds then must go through a process. I mean, there are guidelines set by BBMR, and the only department agency that I know who actually receives cash or non-appropriated monies are the schools, because they have fundraisers. But they have to follow strict guidelines. And the senator, of course, Senator Underwood and I know that coming from the public school system. And we're actually contemplating of creating a bill then that if any cash is to be solicited for or received, that there has to be an accounting of it. And in this particular case, we do know, and the retiring speaker did say, is that the mayors are definitely have been receiving a lot of donations, not just equipment, but including cash, but there still aren't any guidelines in terms to determine the accountability of receipt and expenditures of those monies. So until that until we have addressed then how that is to be done, I will continue then to support the deletion of the word cash.
Senator Morrison, any other senator wish to be heard on the add amendment to strike the word cash?
Thank you, Mr. Speaker. Previous speaker, actually, I want to thank her or Senator Torres for actually clarifying the whole intent of having the donations of cash in there, because there's, if they're not able to even donate the services, that contributors will also have this mechanism to contributing in a form, in a way, through cash donations to avail themselves to these services. So there's also in statute, it's my understanding, that the Mayor's Council of Guam, I believe through the governor's office or the governor of Guam, through certain procedures, can be monetary donations can be accepted already, and there's existing statutes for that. What this provision does is for other contributors who may want to participate this outside of the telecom providers that will donate the services. Again, we spoke earlier about equipment that may be provided for this services. However, we know that there's also vendors out there that participate in supporting the telecom providers that may wish to, or other contributors that may want to support to providing this service. But again, I wanted to clarify why that language was in there, that there are the provisions or statutes or laws that are in place that allow for monetary donations to our government. So I object to this. Thank you.
Senator Nicholas.
Thank you, Mr. Speaker. I just wanted to clarify one of the things that was brought up with respect to procurement. We're discussing right now the proposed striking of the word cash on page 3, line 11. And if you read that section, it says, each mayoral office is authorized to solicit and accept donations of cash, equipment, and services. And they're looking to strike the word cash. But it starts out by saying each mayoral office. So we're already clearly stating that the mayoral office is going to be the one responsible for the receipt of these funds. And on page 2, line 7, under the subsection 4302, broadband access to community facilities, we make it very clear that each mayoral office is authorized to expend funds under its control. Expend funds, which means that they received a cash donation in that previous section, and they expense it under this section. It has to be subject to the regulations set forth in Title 5, Chapter 5 of the Guam Code Annotated. Again, this is underlined language in this bill because it was included by the committee, because we want to make sure that we do follow Guam procurement law whenever we're expensing any funds for the purposes of providing these services. So if the question is, should we be accepting cash donations, I think that can be debated, But if the question is, should we be accepting them because because they might be expensed outside of procurement law, we address that here in this section. So I think that addresses that particular point. Now, with respect to the cash donations, I think we need to take some things into consideration, Mr. Speaker. That being, the only ones that can donate equipment, and definitely the only ones that can donate the services, are in fact the internet service providers. But there may come a situation in a particular village where an internet service provider does not want to donate the service, but they may be willing to donate the router. But somebody else in the village might be interested in paying for the service on an ongoing basis for the benefit of the village. That payment of the service would technically be a cash donation to the municipality, because the individual wouldn't be able to offer the service because they aren't technically the service provider. So the only way the municipality can receive the service is if they first acknowledge that the service is being provided through a cash or cash instrument donation from the constituent within the community. So for example, Mr. Speaker, if I wanted to provide wireless internet services to Dedidome, but I couldn't get a wireless internet service to actually provide the service, then I can go out, make a donation to the municipality of Dedidome, and Dedidome can take my donation and use it to procure the services for the village. We need to keep in mind, Mr. Speaker, that we have only a limited number of internet service providers, and so we can either expect them to donate to all of our villages, or we can understand that by taking out cash, we're going to be limiting the services to only those villages that are able to lock in the internet service provider's service donation. So if there are any individuals out there that want to pay for internet services to be provided in their village, they wouldn't be able to under this mechanism, because technically they aren't the donator of the service. They can only be the donator of the cash to procure the service. So, Mr. Speaker, I ask my colleagues to carefully consider whether we remove cash from this authorized list of donations, because if we do, then we're closing off a mechanism by which these services can be procured for the villages, again, all being routed through the mayor's office and all following Guam procurement law. Thank you, Mr. Speaker.
Thank you. Any other senator wish to be heard? Senator Espaldon.
Just very briefly, Mr. Speaker, the previous speaker is very eloquent in what he was talking about. However, if you really take a look at it, and the argument about cash being a necessary part, if some benefactor from the village would like to donate, I still say that it falls, and again, might be just a matter of interpretation, under, if you do eliminate cash, it would still be available. Each mayoral office is authorized to solicit and accept donations of equipment and services. The donation of a service, in other words, if somebody wanted to pay for the service of internet access, if it's from outside the mayor's office, is allowed under this provision, even if we do strike the word cash. So I'm not sure that the eliminated cash would preclude anybody from donating the services. Thank you, Mr. Speaker.
Any other senator wish to be heard? Senator Tony Abbott.
Thank you, Mr. Speaker. I think what the previous speaker has said, that, I mean, if individuals were to go in and give a cash donation so that this mayoral office may get the internet services, then that's a cash donation that's still going in. And they won't be able to accept it if we strike out accepting cash donations. I mean, I remember a while ago where one of the supermarkets, one of the stores down in Abbott had given the Southern Resource Center internet services, and they paid for it. But if an individual wanted to give their mayoral office a cash donation so that they be able to go in, or the mayoral office may be able to go in to obtain that services, then the individual, all they're doing is giving the cash so that the office can get into that contract or procure those equipment that's needed. And so I think that we still need to include the word cash so that it doesn't exclude anyone from actually giving a donation that wants to give a donation in cash if they can't do it in services or equipment.
Any other senator wish to be heard? Any other senator wish to be heard? Why don't we take a lunch recess?